Every time I check my balance.
ICEA Lion has a plan for everyone. ICEA Lion, what's your plan? I've got a plan that ensures my child's education. So he can become a future CEO.
Hey, Dad.
And pay for my retirement. ICEA Lion has a plan for everyone. ICEA Lion, what's your plan?
I've got a plan.
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 We've got a plan.
I've got a plan.
ICEA Lion has a plan for everyone. ICEA Lion, what's your plan?
I've got a plan to protect my startup so well. Even my pot plants will start clapping.
ICEA Lion has a plan for everyone. ICEA Lion, what's your plan?
We've got a plan that will take care of everything. No matter what turns out.
ICEA Lion has a plan for everyone. ICEA Lion, what's your plan?
Family fighting over inheritance. This is one of the most, frustrating things for, us as attorneys and for the families is when the loved one, the person who passed away, dies without leaving any sort of plan, or they leave a plan that was done 30 years ago and really makes no sense to the situation at hand, what their life is right now. But unfortunately, that happens. People leave the wrong person as their beneficiaries on insurance policies, on retirement accounts. They leave the wrong persons in their last wills, the wrong persons in their trusts, because they just never, for whatever reason, go back and fix things. And when they don't do that, that creates a ton of problems. They may have wanted to make those changes, but if they didn't, a lot of times you're stuck with what they wrote 20, 30 years ago. So update your plan.
Hello and welcome everybody. We are thrilled to have you join us today for this webinar on the art of family wealth. At ICEA, we have been loyal to our promise and we've been all the time, looking at our mission of protecting and creating wealth. That is why as ICEA Lion Group, we offer you a myriad of solutions, ranging all the way from ensuring all aspects of your life, including your life itself, including your property. We have ensured that we are going full circle by investing, ensuring that we grow our wealth over the years. We have our pension solutions that ensure that even as we age, we are able to take care of ourselves in retirement. And completing the loop is our trusts, which then ensure that we are able to have this wealth that we've created, then transition into the next generation seamlessly. So we offer end-to-end financial services. And this is exactly what our promise is, that through every life-changing moment, we are going to be better together. So therefore, whether you're a seasoned financial professional who is on this call, on this webinar, if you're a family member who involved in wealth management, all of us are. We are all part of families. Or if you're simply curious about how, to look at your family wealth, or curious about how estate planning is done, this session is designed to provide you with valuable insights and also practical knowledge so that, we can demystify, getting the wealth across generations, preserving it, and achieving specific personal or philanthropic goals that you may have. However, understanding the intricacies of estate planning and, sometimes even managing these estates, whether it's a trust fund and so on, this could be complex and even daunting. So that's why we've gathered here today to listen into an expert who will break down the fundamentals, share the best practices, and ultimately answer your questions. So feel free as we go on with our chat to, as we go on with the webinar, to ask your questions through the Q&A. We will endeavor to answer all of them as we go on, and ultimately also answer all of them towards the end for the sake of everyone else. So we'll cover a range of topics, including the basics of estate planning, the benefits and drawbacks of it, how you may manage and administer, and of course, where possible, we'll give you real-life examples and case studies. We encourage you to actively participate by asking questions, sharing your experiences, and engaging with our speakers and, through the chat and the Q&A fellow attendees. By the end of this session, we hope that we'll have a clearer understanding of how we plan our estates and how we can leverage that to meet our unique needs and objectives. Once again, thank you for joining us. Let's dive into the world of the art of family wealth and discover how, this could be a plan for us, a powerful tool to ensure that we secure not only our own future, but our family's financial future as well. So now let's begin, and I want to request Winnie, who is our speaker for the day. She's an advocate of the High Court. She is really an estate planner, very passionate one at that, to take us through her presentation. Winnie?
Thank you, Moses. Good morning, everyone. Thank you for joining us this wonderful morning. I hope you're ready to learn, as we are also eager to interact with you. Feel free to chat us, but also feel free to place your questions on the Q&A section. They'll be answered at the end of the presentation. But as an introduction, Winnie Mengi is my name, the estate planner within ICA Lion Trust, and an advocate by profession, but I call myself the family wealth advocate by calling. So just to begin us, I will share my screen to a presentation that we prepared today. And yes, happy to be here. Just allow me to share my screen. Moses, please confirm once you see the screen.
Yes, we have your screen.
All right, very good. So today we are discussing the art of family wealth, and family wealth is something that is very near and dear to all of us, whether we know it or we don't. And I hope that at the end of this presentation or at the end of this webinar, you will leave with a conscious decision to just note down what you own and how you own it and what you can do with it going forward. So the basic plan that we create, or the plans that we put in place, are always to protect the ones we love. We don't buy a car so that we can get involved in an accident. We don't buy a home so that we can get robbed in it, but it's the reverse. We buy a car so we can secure mobility, we can secure certain movement for our families. We also buy homes to secure shelter for our for our children, for our parents, for ourselves, and we always protect the ones we love, starting with ourselves and streaming to the people that we've created. So in the discussion of family wealth, we always peg the family from whatever generation you start at, whether you are the first generation in your family or you are the third, fourth, fifth generation in your family. It is very good to be founded on value and principle. And the principle that we set our estate planning or family wealth protection is centered on the biblical principle of leaving an inheritance to our children. Creating family legacy begins with that. It begins with once you've created an inheritance and once you've bought property, you've bought cars, you've set out bank accounts, you simply just say, oh, I have something to leave behind. How do I do it? Leaving it to chance is not what we're trying to do here, okay? So we look at historical figures who tried to do estate planning and those who didn't try to do estate planning, and we kind of place ourselves in their shoes at that time. We tell ourselves, okay, any fool can make a fortune, sorry. Any person can buy a home. Anybody can try and create something with what they have. But it takes someone with brains. And this, I would like to say, it takes a wise person to hold on to what they have created. So Cornelius Vanderbilt is one of the oldest, richest people that we know. Of course, he's not alive in this century, but he was in the 19th century. And he was very clear to note to his son that you need to be wise enough to maintain what we have created. But how did their story pan out? How did they continue building their wealth or not building their wealth? And we're going to place them next to the Rockefellers, who we've heard of today. We've probably interacted with some of their products and services. And we want to see what exactly did one family do versus what another family did. The Vanderbilt, original Vanderbilt, Cornelius himself, left a will. And in speaking to his son, he was trying to pass on the value of wisdom. Have wisdom in how you're navigating your wealth or what you're receiving from me. But there were no restrictions, there was no directive on how the inheritance should be used. And unfortunately, it was squandered by the third generation, and that means the time his son's son was getting a child, they had already depleted most of their wealth. They didn't even cross over into the late 20th century with any kind of wealth. They had spent lavishly, they had tried to, live up to their lifestyle. Maybe there was some lifestyle creep also with the changing of times and improvement of technology, but that was it. There was no clear plan on how that wealth was being transferred, and therefore their fortune was literally depleted. But on the flip side, the Rockefellers did a different thing. Yes, they were part of the millionaires in the 19th century together with Cornelius Vanderbilt, but their father did something different. He set up a trust. He decided, you know what, I need to give them some certain instructions and restrictions on how this wealth that he had sweated for would be utilized for time immemorial. In the trust, he decided, let's set up a family bank that is able to preserve our wealth and also allow the children of his children to still find what is there and multiply it. They maintained their charitable givings. They set up a family constitution which governs not only the social structure of your family, but also the values and the principles that you set in to your family. And that current family is valued at $10 billion today. That is something that was just one spark, a spark of a person who was simply a millionaire back then in the 19th century, who decided to do something different. When we come back home, we see a lot of newspaper discussions and articles that really send us the wrong way when we talk about succession. We start with the people who are at the creme de la creme of the society. The delayed inheritance is simply because people are not able to honor your instructions, or they just want to go with what they believe they wanted from you. The estate is governed by what you own, and therefore what you own, we want to do with what we want. So they just end up fighting and fighting and fighting one another. We've seen countless articles on how succession has depleted or wasted assets in the country, both in the cities and the rural areas. We've seen families fighting almost to the point of ending each other's lives simply to get what belonged to their parents, what belonged to their grandparents. Siblings are fighting left, right, and center to try and get the better share or to try and get the bigger share. And that is the narrative we're trying to change today. We want the news to start saying how excellent succession plans have been. We only have one article that shows, how Kenyans think around succession. How many cases are there under succession? This article was written by NWealth, but currently in the news today, there are over 13,000 succession cases simply in Nairobi. Those are 13,000 families waiting to receive what belonged to their mothers and fathers, grandfathers and grandmothers. Some span years, decades even, in waiting to have the court grant them that power to use those assets. 2 out of 5 Kenyans who are already pensionable, so this means there are people who are probably salaried, have written a will. That's a dismal number compared to the number of Kenyans who own assets, number of Kenyans who own pieces of land, bank accounts, M-Pesa accounts. That number is extremely dismal, and we want to change that part of our planning. We want to encourage us to simply put our plans in order. We've already seen how succession planning can go in the reverse if you do not create a plan. And the risk of losing what you already own is very, very high. That risk is simply because you've not talked to your children, you've not talked between as spouses, you've not talked with your parents, you've not explained to them how you would like to use their property, or they have not explained to you how they would like to transition their property. So already within the family, a big chunk of how that wealth can be depleted has already been exposed. So you've taken up one risk. You've not prepared anybody to take over your business, for instance. You've not prepared anyone to take over your online business, your digital creation business. You've not prepared anyone to receive it. You've already exposed yourself. We're at 85%. You don't have a family mission. In this family, we value education. We don't have that. In this family, we value charitable giving. In this family, we make sure we give back to the church as and when we can. You don't have that family mission. So you've already exposed yourself a further 12%. Now you're left with the 3% that can try and salvage a little bit of what risk your family faces. And that is legal and tax and investment advice. You've come to the webinar today and you've taken up that part. You've said a small window needs to open to make sure we are ready and able to receive what our parents have, what our children have, what where we're able to give ourselves this advice and move along with it. So you've already seen the risk that you're taking. Now, what kind of system are you creating? How do you want your family to be set in place? You may be the spark that is needed to light that fire. The fire may be felt by you in your lifetime, or it can be felt by your children and your children's children, and they will be glowing under that fire saying, we thank God, or we are so grateful to our mother and our father for sitting in this webinar and taking notes and making sure they have put in place a plan for us. So the estate planning is centered around 3 crucial aspects in the family: the people who belong to the family, the culture that they've set within that family, and their wealth, what they own. Yeah. So within the wealth ownership structure, you must remember that you're not only dreaming up children, you're also dreaming up their lives, their wants, their wishes, their needs and desires. You want them to have a life that is better than yours. Your parents would have wanted you to have a life that is better than yours. You have relationships that you forged right now. You have future relationships that you're going to forge. You're probably on the journey to get married, or if you're married, you're probably on that journey trying to set a plan for your children to go to school. If you're in the unfortunate situation of facing a separation or a divorce, this is the point where you start building a family tree and understanding who belongs to my family and who can my assets affect. You have family beliefs. People who are centered on the church. We have people who are centered in Islam. We have people who are centered in traditional values. They would like to maintain a legacy property, a home where they can continue subsistence farming. That is very critical when you're creating that family system. And the third and also important aspect is what you own. You have information, you have your real estate, you have your gadgets, you have your intellectual property, you have your social networks and business partnerships that you build. All of them need to come together in a formal structure such that the system can start grinding. You get the gears moving, so you can always work backwards. You've seen that the risk I have is I've not communicated with my family what needs to be done. So now what do I need to know? Yeah. How do I need to know this? It's a very important thing to remember that life circumstances are not just you. Life circumstances are also the children you have. Life circumstances are also the children they will have. And running backwards, the children you might not have, the parents you take care of, the people you have adopted, the dependents you have. So create a system that works well within your family structure. We don't want to read of your family in the news or see them fighting and throwing stones into each other. Yeah. So it's not a thing to say, I want them to think about it themselves. When you're sitting down and saying, I'm creating generational wealth, you started with mental health, you've started with emotional health, you've started with physical health, and now you're on financial health. So maybe you're exercising and you're eating right, and you're probably going for therapy if that's a thing you want to do, but you've not set your finances in place. It can still set your family backwards. When you're sitting down and thinking, oh, what am I supposed to talk about? Am I just simply thinking of the day I pass away? We are mortal beings, but we are not wired to think about the day we pass away. We just want to live in positivity. And living in positivity means you create a plan so that you can see yourself beyond today. See yourself in the future. See who can take care of your heirs, who can be a guardian to your children, who can protect your property, who can you leave your bank account with, and they will not splurge or use it for, their personal frolicking. They simply want the best for your family. Those are the decisions you're making when you're sitting down and contemplating estate planning. You want them to know how you've structured yourself. So the simple definition of what estate planning is orderly administration and distribution of your property, which can happen in 2 times: during your lifetime and after you pass away. So in your lifetime, you're still able to create a plan that will not only favor you, but will also favor your family as it stands today, and it will continue favoring them should you not be with them tomorrow or 10 years from today. That is the plan we're talking about. Of course, it's centered on the laws of this country. Everything is founded on the Constitution of Kenya, and we all have the constitutional right to own property. Therefore, the land regulations come into place. The Income Tax Act is also very crucial, and we are in a discussion around what kind of income tax will be faced when I do estate planning. Those are the milling discussions around the country right now. But even in the knowledge that Income Tax Act affects you, it will not stop affecting you whether you stop creating your plan. It will affect you either which way. Yeah. So the Trustees Act and the Law of Succession Act help us navigate that part. They help us think about, oh, this is the law that I need when I'm trying to create a trust, for instance, or when I'm trying to set up a trustee, what do I need to know about guardians? How do I navigate my property through a trust? Those are the discussions that we're having today. And I would like to welcome you to think about what you own. What do you actually own? What forms part of your estate? When you think about your estate, how are you pegging it to yourself? Is it just the apartment you've bought, the home you live in? Is it simply the car you drive? Maybe you own a gold bar somewhere. Maybe you own a business. You probably have household valuables you've imported, or you've locally made all your household furniture, and they're valuable to you. Those are valuables even to your family. You own your family itself. Your spouse, your children, your parents are all part of your estate. These are people whose decisions can affect your today, and your decision can also affect their today and their tomorrow. So you have money in your bank account. Maybe you have money in an M-Shwari account or an M-Pesa. You have some plot of land that you've invested in, whether with yourself or with other people. You have things that you have invested in. You have carried on financial knowledge well enough to understand bills and bonds and shares and fixed income funds well enough to even assimilate yourself and buy them. Those still form part of your estate. If you do not have a plan, if you do not create a plan, or you do not leave any kind of instruction, the person you leave behind will need to go to court. They will need to verify that indeed you passed away. They will need to go to the nearest chief of the area that you lived in. They will then provide evidence that you owned something and get consent from all your family members to be able to distribute what you own. In the late 2021, we had a law that has amended the Law Succession Act, but it has yet to come into force, where they were removing the discriminatory right that is given to widowers. A man who is left behind by his wife needs to prove that he was being maintained by her so that he can inherit from her. That law is a bit punitive in this day and age where we have equal working partners in marriages, and that can actually frustrate widowers when they're trying to prove that, no, she was maintaining me. How do you prove that someone is maintaining you? Is that the headache that we want to carry forward? Is that the plan that we're leaving behind? Are we trying to tell them, figure it out for yourselves? No, because you're here today and you're seated and you're taking notes, you're here to say, I want a different future for my family. I want them to know that I had tools at hand and I used the tools that were available in the day that I wanted to create a plan for them. I needed them to be okay, and therefore I created a plan for them. So let's start with the first plan, the first tool that you have, and it's at your hands. You can use it when you want. You can create it even today, this moment. You can simply create this plan, and it's what we call the Advanced Medical Directive. It is created through a power of attorney. When you sit down and decide, I would like for my spouse to make a decision about my life. If ever something came at me, or a terminal illness, or I'm involved in an accident and I happen to need life support, I need them to make this particular decision. Yeah. It's never the right time to tell them that I've made this decision. Therefore, it's always the right time to do it yourself. Do it now, and then you can talk to them and say, no, I've already created this decision for you. And they will only learn of that when it's time to make a decision. Okay. So we are very faithful. We are hopeful. We get positive when someone falls ill, and we tell them, no, you will make it out of this. But what if the prognosis is different? What if they have been told you only have 4 months to live in this day and age where we have terminal illnesses that have advanced so fast that we're not able to guarantee someone the next year? Should they give you the medical directive to say, please do not resuscitate me, please do not put me on life support, will you honor this decision? If they give you that advance directive, you will more likely than not honor that decision because you know it is what they want. We love the people we love and we honor their decisions, much as it might be scary, much as at that moment it might seem like a very daunting decision. You've already alleviated the burden. You've lifted the burden off of them, and you've told them, look, I want to make this decision for you. I want to make it easier for you. When you hear that I am in a hospital, please know that you are the person I have given charge over my person to make sure I am well, or if I'm not well, these are the things that I need done. The second tool that we have at hand is a will. So we have two types of wills, either an oral will or a written will. So an oral will are those ones that are spoken out. They have no other feature other than it's a word of mouth given to at least two people. And those two people are the only witnesses, or more than, if there are more than two people, those are the only witnesses to what you spoke. The caveat to that is if you speak out your will, and they were mostly known as deathbed wishes, you must pass away within the 3 months of you speaking out that will. So it's not every day that everyone goes around saying, you know, I would like for you to take my car if anything happens to me. And then you live on to 2026, you are still here with us. That will is already invalid in and of itself. So the best option is to have a will that is written down. It has clear expressions of what you would want done with you, with what you own, to who you own, and that letter of instructions is very, very well placed in the document and it's signed by you. So there's the option of, I'll speak it out, but are you guaranteed that you will pass away within 3 months? And this is, I mean, excluding the members of our armed forces, because they are allowed to speak out wills for as long as they are in active combat. But for us civilians, we know when we speak out our wills, we can't guarantee the date of our death. So the more secure option is write it down, write it and sign it in the presence of two people. They should be independent, meaning they're not benefiting from anything within your estate or from the will itself. And they should be competent enough to say, I was present. He or she knew they were writing this will. They knew I am in charge of witnessing your signature. So you sign the document, tell them it's a will, and they sign that you have signed and you are lucid and conscious when you are doing that. They don't need to know the contents of your will. They simply need to confirm that you are the one who wrote that will and that you are conscious in making that decision, that it's a will you're signing. When we talk about wills, there's a very nice series on Netflix right now that can show us how a will can change the life trajectory of your heir. One heir expected to receive the entire estate and be named the king of that estate, but the father changed his mind. At whatever point he changed his mind, he decided to give not his firstborn son, but the younger son in charge of his estate. The younger son who had moved away from home, the younger son who was already in active duty, he was not present in the estate for the duration that his father was unwell. But his father wrote the will and wrote out his firstborn son and indicated that the younger one would take over the estate. That is what we call testamentary freedom. You have free will to do what you would want at the time you're writing your will. You, the maker of the will, being the testator, you have a will and power to say, this is the guardian of my child. This is the guardian of the person I'm taking care of who may be of special needs. This is the executor. This is the one I'm leaving in charge to make sure the will is followed through. They have taken it to court, they get the grant of probate, and they're able to distribute the entire of my estate as I have decided. The witnesses are also determined by you. These are people who step in and say, yes, he's writing a will and I've witnessed as much, and they leave their contact details in case someone challenges that you wrote your will when you were conscious and aware. Beneficiaries and heirs are the most important aspect of your will. So the person who is receiving, yeah, at the top you have the person who is giving, and at the bottom you have the person who is receiving. They're the most important. If you do not have a beneficiary, it will be left to the state, or they'll try and do it through intestacy. They'll now move the court to help them give instructions for who can be a beneficiary. If you do not have children, think about your beneficiaries as institutions. They could be an organization that you support. Probably it's a religious organization, or it's a charitable organization, maybe a children's home. You can name that as your beneficiary, because it's very important that the parties of the will are clear, directed, and specific, so that the person making the will doesn't leave the will open to interpretation or misinterpretation at that. When we move on to the next tool, here is where the art becomes even finer. You know what the word trust means. We all say trust is earned, but some people believe trust is lost. Yeah, I trust you until I don't trust you anymore. But for some, it's I don't know you, therefore I don't trust you. Until I know you, then I will trust you. But when you're coming to a family trust, those are the questions that you place in your mind. Is it that you want your trustees to earn your trust first, or will they lose your trust? And both situations may apply. There are people who do not know how to serve as a trustee until they're appointed as one, and therefore they might need extra guidance. But when you're talking about a family trust, we think about the entire family, what the family owns, and how they are placing it under the trust. What kind of instructions are they giving? Is it simply to give to charity? Are they gifting their children? Are they making sure the money can grow? What are they trying to do within the trust relationship? How are they building the trust? There's also a very interesting show on Netflix that shows how a lifetime trust works. When you're trying to build confidence in your children and you're trying to show them, I believe that you can manage this well. I believe that you can run this business, but I would want for you to be put to the test. You can put them to the test under a trust. And we've seen how the heirs of the person who's created the trust, who was the grandfather, have day after day tried to get the trust overturned, tried to get their distribution done, tried to get their gifts out of the trust, but they are simply unable. They must maintain the trust. They must work within the instructions left in the trust, and they can create their own trusts within those trusts as well. So remember, a trust is simply, it's a conversation you're having, but it's also a description of a person. It's also a description of a relationship, and it's a feature that works very well when you're building a family trust. So what do you need to create a family trust? There are three simple things: a reason or a purpose to create it, a beneficiary, so who is receiving what you need, what you have, and what you actually own, what is being placed under the trust, so that it can meet the purpose of that trust. You're saying, I want to have a legacy property, my home should not be sold, and I have a reason now to put it under trust. Therefore, and my home is the asset I'm putting under trust, and I would like for the people that I live with to continue enjoying my home as a living premise. Therefore, I have a reason, I have a home that's an asset, and I have people who can benefit from that asset, who are the beneficiaries. So we've already satisfied the three essentials of a trust, meaning every single person can create a trust. Then you discuss within your family, or you come and talk to us and ask us, what kind of a trust can I then create so that it can benefit my beneficiaries? How do I fulfill the purpose that I have within me to create a consolidation of what I own? The express trust is the best route to creating a trust. There are implied trusts where you give someone an asset and you tell them, please hold on to this for so and so, and that is implied. But express means it's written down. Everyone can read it. People who don't know you and people who know you likewise can read what you've written down. You can write it down either through a will, meaning it's testamentary, or you put it in your lifetime, where it becomes a living trust, it comes alive with you. You can simply say, this is the trust that I've created for my children, and this is who I am, okay? So to create a living trust, you can say, I want a trust that I can cancel in my lifetime, or simply say, I don't want this trust to ever be cancelled. I want to put my house in it, and nobody should remove it from the trust, and everyone should be able to take over the house through the trust. So you have the irrevocable trust and you have the revocable trust. When you create the revocable trust, that's the one that you can cancel, withdraw the funds from that trust, and move away from it. But an irrevocable trust means it can't be cancelled. Nobody can take the property back to themselves, and the property remains in the trust for so long as there are beneficiaries and there's a reason for it to stay within the trust. It does not mean you cannot dispose of it or sell it later. It just means that as the person creating the trust, you will not now come and say, undo the trust, give me back the asset. No, you've created it, you said no one can cancel it, and the no one is also referring to yourself. There are key parties. The same way we saw key parties in a will, there are key parties in a family trust. The first person is the one who's setting up the trust, the settler. In the countries of Commonwealth, we call that the settler. In the Americas, they call it the grantor. The grantor or the settlor needs to be sure that they have a set of assets that they'd like to place in the trust. They have certain terms and conditions of how those assets should be used within that trust, and they place those terms and conditions in a document called a trust deed, and then they appoint the trustee who manages their trust property. The trustee, see, the settler has already moved the management. The trustee then becomes the one who runs the trust property. They can be a natural person, meaning a human being like you and me, or a body corporate like ICA Lion Trust that can take over the management of that asset for the people placed within the trust. They must adhere to the rules that have been placed by the settler in the trust deed, and they have the personal and ultimate responsibility to make sure that their duties are carried out well. They must ensure that the assets are maintained status quo. They must ensure that there's some form of responsibility that is taken over and that they care for it in good faith. Then you have the people who have the beneficial rights to the trust. The person who the settler said, hold these assets for this person and this person. That person is called the beneficiary, and they hold the beneficial interest in the trust. The settler can also be a beneficiary. And lastly, we have the person introduced under the Trustees Perpetual Succession Amendment Act of 2021 called the enforcer. So previously, the enforcer was the court. Everyone would run to court. See, the trustee has done this. See, the beneficiaries are doing this. Oh, I'd like the trust to move on like this. Now you have the enforcer. You've been allowed, you've been given power through the law to create this person. It could be a body corporate or an individual who then takes over the role of governing the trustees. What are the trustees doing? How are the assets being managed under the trust? Do we need to amend the trust deed? Do we need to keep the beneficiaries in check? That's the role of the enforcer, the person who is called a protector. They come in to protect the terms and conditions set in by the settler. So the basic structure of the trust, once you've seen the key people participating in the trust, the basic structure of the trust is you as a settler, or you and me as a settler, we have an asset that through a trust deed, we are placing under a trust. So we create the box called the trust, we put in the trustee, we put in the enforcer, we put in the beneficiaries. The beneficiaries can also include the settler themselves. They say, look, I want you to manage this property for the benefit of the people I've put in this trust. I want you to register this trust deed. I want you to make sure the property is managed properly. I need you to ensure that the trustee is working properly. That is an instruction to the enforcer. And then you streamline the benefits to the beneficiaries. You say what they can be given, what kind of education plan they should have, how their health should be managed, whether they are ill, whether they are well, and now at some point they'll need some Medicare. You can simply set those instructions down in a basic form of a trust. The trust setup is very simple. It's a very simple route. It's a two-step route. Yeah, you're still at the risk mitigation. So we are mitigating it and saying, I have a trust document. I've seen a will. I don't know if the will can help all of my assets. So I want to create a set of instructions through a trust deed, and then I want to move all my assets into that trust deed, into that trust, so that the trustee can continue managing them. I am still here, I am still alive. I would like the trust to continue benefiting me. I would like to participate in also the navigation of the trust instructions to the trustee, and you move it along in your lifetime. So it's just a two-step process that allows you to now create a whole legal person that can take over the management of your trust. Are there any tax implications? There could be. Depending on how you structure your trust, there could be tax implications. But the law as is today offers you two incentives: that there's no tax when you're transferring property into a family trust, and those two taxes are stamp duty and capital gains tax, and that a trust cannot be charged corporate income tax. So the corporate income tax currently is at 30%, and a trust is exempt from corporate income tax. So you have a tax benefit that allows you to move the asset into the trust at no tax, and to continue managing the asset as you would without that person being considered an income earner, and therefore they are not chargeable corporate income tax. Any other income tax that is outside of income tax may be chargeable, but depends on what you're putting in the trust. So for example, investment income is taxable to all, corporate or otherwise, and therefore we all pay investment income tax as withholding tax, and it's a final tax payable. But the trust will also not be considered an income earner. The trust cannot trade, therefore cannot earn an income on its own. It can only earn an income through the assets placed under the trust. And not the last thing, but almost to conclusion, is how do you now decide who becomes your trustee? There are many decisions that go into setting up a trust. That you yourself have an asset. What kind of an asset are you putting under the trust? We've seen the parties that you can create, but here is where the rubber meets the road. You start deciding, do I add my children? Am I also part of the trustees? Am I going to put it as my friends? Do I get an individual board? Do I hire a professional trustee, that being a corporate trustee? Currently, in the country, we only have corporate trustees as professional trustees. So you need to decide, weighing the pros and cons of both. The pros of having an individual trustee, being maybe your family member, is that they might not charge you professional fees to serve as a trustee, but they might also have a personal benefit in that trust, and there could be some bias that is coming from them. Or you put a personal friend who does not put it as a commitment to serve your trust. So as opposed to a professional trustee who might charge you, but they will treat it as their business interest to make sure your trust works. When you have an individual trustee, you need to ensure that the person you've put in can work, can do it in good faith of your trust and of the people that you've placed under that trust, and that maybe you can compensate them in one way or another, but they understand that they're doing it at no cost. But either way, you can select an individual, a corporate, or both. You can still merge both to allow the professionalism to also flow into the individual trustees, to allow them to understand their role as trustees, because it is on the trustees that the trust is founded. In conclusion, I'd like to remind us that when we started, we said, this is the thing that we are doing from ourselves. Whether you want to involve your parents or your grandparents in this discussion, or you now want to start involving your children in this discussion, the idea is to set the plan in motion. To start with, I don't want them to face the problem of looking for a chief. I don't want them to face the problem of, fighting in court. Therefore, I want to create a situation that allows what I value and what I have owned to live beyond my lifetime. So it is not a conversation of death, but it is a conversation of futuristic planning. Thank you very much for listening to me. Thank you for also connecting, and the questions can now start coming in. I'll get the conversation back to Moses, and I'm happy to answer as many questions as you have. Thank you and have a good morning.
Thank you, Winnie, for that elaborate presentation. Of course, where I come from, estate planning is very easy. You have a homestead. The first son builds on the right, the second son takes the left, and then like that. So it was really very easy. However, I'm guided that with the complexities of what we own now, the complexities of society, that perhaps that method that we were using possibly does not cover everything, and it's not foolproof. And ultimately, because we are living in newer times, then we have to continuously engage to find the best way and, preserve our legacies as we continue to grow. So the questions are coming in thick and fast. I can see a lot of questions on the Q&A. The team has been answering them live. However, there are quite a number, and we are encouraging you to keep them coming. So without much ado, I'll start taking us through, this segment. So there's a question here by Timothy Ndome. Can the irrevocable trust be challenged, or changed due to changing needs or aspirations of the family? And as you look at that, the output here is asking, is it conflicting to have a will and a trust? Shouldn't the trust, suffice? Then there are questions that relate to taxes. There was actually a comment by one of the participants that looking at just two of the tax items that have been mentioned, does it mean so that then the corporate tax is the only tax benefit from a trust? That was the question. So kindly take those as I compile the others for you.
Thanks, Moses. Those are good questions. I'll start with the trust question. Can an irrevocable trust be challenged? My answer to that, simply from my legal heart, is anything can be challenged. Anything can be challenged. I can challenge that Moses' background is not green, and that is up to me to challenge. But the thing to mind is, can they challenge succeed? Is it possible for it to be successful? You can challenge an irrevocable trust, but the chances of it being successful for you to undo the trust are quite minimal, okay? You can always amend the trust. The trust is very flexible to allow changing circumstances of a family to be accommodated within the trust deed. So say you've named beneficiaries and those beneficiaries no longer exist within the family. And I'll give an illustration where married couples create a trust and they're beneficiaries within the trust, and now they are separating. They can remove themselves from the benefit of the trust and leave their children as beneficiaries of the trust, or however they so choose. The changing circumstances of the trust deed are flexible enough for the settler to say, I'd like to amend this part of the trust for so long as it is in line with the law and it does not deprive the beneficiaries of their beneficial interest. So you're not removing the asset to create a void trust. So you're not changing because there's an illegality or an unlawful action that you're taking, but you're simply changing because there are circumstances that have changed in your family. The second one is, should a trust suffice? Yes, it should, but we already have assets that we own in our personal names. And to name but a few, we have fixed income funds like money markets, we have bank accounts, we have M-Pesa accounts that you own in your personal name. These are accounts tied to your national ID. You cannot transfer them. You can only close and open a new one in the name of a different person or a different entity. Therefore, for so long as it exists in your name and for so long as you're alive, it is best to create a way that it will flow into a trust that you have created. And the only tool that you can use to do that is a will. So having a will and a trust deed almost is a foolproof solution to your estate plan. You can have either or, but having both allows you to see the things that have been excluded by you creating a lifetime trust. How will they now flow into the trust itself? Have I answered all the questions, Moses?
Yes, there are many questions. Actually, we have upwards of, we're approaching 60 questions. There are questions pertaining to the implications of the proposed finance bill on taxes of trust. I just want to confirm that, those are proposals that have been made. There have been counter proposals. I want to, inform the attendees that as ICEA Lion Trust Company, we gave our submissions pertaining to what our views were in terms of this. It appears that there was some kind of consideration of the submissions that we put forth, looking at the report from the committee, whereby, for instance, there was proposed taxation when we are transferring property into a trust, and the committee really saw our point that, when you move money from yourself to the trust, there is no change in really beneficial ownership and so on. So it's not a transaction that ought to be taxed. So largely those items, based on the committee report, they did not see the need to include them. However, because the process is not yet finalized, we do not have a Finance Act yet, we can only be positive that those changes would be adopted as per the proposals. But that is the process where we are at. That's where the process is. So I hope that deals with the issue on taxation in general. There is a question here, Winnie, which I find interesting. There is a lot of mistrust, according to Tom Kenywa, in Kenya involving third parties managing family wealth due to theft and personal enrichment of those entrusted with such resources. How do you reassure clients that they can trust your managers? As you take that question, as you ponder that, there is a question by an anonymous attendee here. Given the ever-changing legal and regulatory framework, is there a risk that the currently exempted trust could be taxed in future? And under what circumstances, can a will be revoked or changed after the demise of the owner? Could you take those two as I sample these questions? Ladies and gentlemen, your questions are also being, answered by a number of our colleagues on the type, but who are typing the answer. So you'll bear with us if yours is not mentioned, but it will be answered on the chat. Winnie?
Okay. So again, remember, trust is a description, it's a relationship, it's a definition of how we view ourselves. Am I trustworthy enough to be in charge of my brother's or my sister's estate, even if it is just their car? Am I trustworthy enough to grow or invest this for someone else? Where we reassure clients on trust and trust relationship is because, one, where we sit as ICEA Lion Trust, we are corporate trustees. It is within our core mandate to ensure that what we hold in trust is held in good faith and also for longevity and for the good of the beneficiaries. It is we are earmarked for that, okay? So as a company, the assets do not belong to ICA Lion Trust. The assets belong to the individual trust that has been set in place. So once you are made aware of that and you are simply managers of that asset, and you understand that as a trustee, you can remove yourself or you can be removed from that trust, then it is up to you to measure the performance of the trust, to understand that it is your role to ensure certain assets are held and maintain status quo, meaning they're not depleting, they're not wasting, they're not gaining any kind of penalties, whether those penalties be tax penalties or other government regulated penalties. So you're making sure rates are paid, land rent is paid, you're making sure that the asset remains compliant within its legal jurisdiction. And that is the reassurance we offer as a corporate trustee. But speaking on individual trustees, it's very important for us to remember when we are setting up a trust, you're actually telling this person, take this and take it as your full responsibility to make sure it works and works for the good of those I've put under the beneficiary list. Yes, a trustee can also be a beneficiary. So you can name your child and you can name yourself as a beneficiary in that particular trust. And you can name as a trustee as well. So you can learn to manage the trust and you can help your children gain the financial muscle to manage the assets that you've placed under that particular trust. Nothing is cast in stone. Doesn't mean that if you name individual trustees today, you cannot hire a corporate trustee tomorrow. You hire corporate trustees based on their values and their reputation, and you also understand how they have managed other private wealth estates before you hire them, so that you can know that they have experience, you know that they know how to manage private wealth, because private wealth and public wealth are two different things. Private wealth speaks to a particular person and their unique desires and wishes over their families. In the same breath, I want to say that even if you set a trust under a will, you can still guide your trustees, how the trustees should be appointed, who should be appointed. You can still guide and give instructions on how the trust has been set in place. Can you overturn a will? Yes, you can challenge a will. Is it likely that it will be set aside? Because we don't say we revoke wills. The court simply set aside the will and let the estate run under intestate succession, where now it's determined as if there were no instructions left by the settler. If you want your will to be watertight and foolproof, it's best to have legal guidance in writing that will, so that you know where there could be a bottleneck in your family. Maybe there could be some bit of complaints, disputes, because it is the very beneficiaries that you're leaving your assets to in your will who challenge that particular will. If you leave someone out, if you give them something that they feel was not sufficient for them, they can challenge your will. It is up to the court to help them determine whether the will was written well, was written sufficiently, they've been covered appropriately, and therefore the court does not need to turn it, to set it aside. But that has been left to the court's determination. You write your will and you go to your maker, and it is up to your family. Whether there's a challenge or not, it is up to the people you have left behind. Because the rule of thumb is, if anyone wants to start a fight, they can and they will. Whether they win that fight or not is up to the court.
Okay, I see some questions here. There are two questions. I think both of them are from PR. They relate to retirement benefits. I think I'll take that. Susan Madenge, be ready. I'll be asking your questions so that also the rest of the panelists can answer. So there is a question here from PR. Please clarify the issue of transferring retirement benefits to a trust fund. A retirement benefit scheme clearly defines who a beneficiary of a member can be, typically limited to natural persons and often specific to family members. I understand how benefits can be transferred to a trust while the member is alive and exiting the scheme. However, how can retirement benefits be transferred to a trust after the member's death, especially when there are individuals who can prove dependency but are not declared as beneficiaries in the trust fund? How can this be done without legal challenges? Allow me to take that. with your permissions, of course. When it comes to retirement benefits, yes, the trust deed and rules for each scheme defines what happens or who gets paid at the point. So under the current legislative framework, of course, a scheme has active members who are still contributing, deferred members who've left and have a portion of their funds still in the fund. We have, various modes of people getting paid as they exit. So one of them, unfortunately, is death. So in the event somebody passes on, then you cannot pay the person because obviously the person is dead. So typically what has happened traditionally is that then you would pay those who have been nominated under a nomination of beneficiaries form. So these are forms that you complete when you're still there, indicating who you would want to be paid in the event that, unfortunately you passed on. So typically people would put in their spouses, their children, their parents, and so on, and any other person, who can be defined as a beneficiary by law. And usually that is somebody who depends on the deceased person for the necessities of life. So somebody must meet that threshold. So for a long time, this was paid to, say, a third party who was a guardian, especially for minor benefits, and the guardian, sometimes not because of their intention, of being intentional to misusing the funds. Obviously, say, suppose somebody is 1 or 2 years and you've gotten a retirement benefit on their behalf, and you get 2 or 3 million shillings. It's unlikely that 2 or 3 million shillings will be in existence, 10, 20 years later. So it has not become a very effective way. So the other alternative has been to set up a trust, whereby then you can pay monies into that trust. Of course, for various quarters have indicated that, look, who is this trust? That person is that a beneficiary? So some lawyers ask, could that be a stranger? Fortunately for us within this jurisdiction, there are express provisions, and I would want to refer the gentleman or the lady who's asked that question to the IDD regulations, regulation number 15, which has expanded beneficiaries of trusts to minors who are aged below 18 now. So that means that it has legal basis. So that's a law that was changed, regulation 15 of the IDDs. So you can be able to find that. And the reason really has been that, again, the law, the Retirement Benefits Act and regulations require that you identify and pay the correct beneficiary or the right beneficiary. So that guardian that has been paid for very many years is actually not in any way, shape, or form the correct beneficiary. The right beneficiary has always been the minor. So how do you get to pay the minor? And that now has been addressed through that amendment. Other questions? I have a question here for Susan. I saw a question here whereby there is a question is what happens when the assets of the trust are finished, Susan? Winnie, I'm coming back to you on the questions of the relationships between a trust and a private company. So where we have a trust and a private company, what relationships can exist and what are the benefits of that layering? Should a person opt for that? And another person was very particular whether it is better to have a trust and a holding company together. So Susan?
So what happens when the assets are finished? So normally we have 2 types of trusts. We have a revocable trust and we have an irrevocable trust. So most of the time when you have assets which are likely to finish, for instance, something like cash, you'd want to place them in a revocable trust whereby they serve a purpose and they will depreciate for maybe being used at one point or another. So when you find, we normally advise that when you're setting up a trust, look at the kind of assets that you wish to place in that trust. So if it's an asset which is likely to depreciate or it's likely to get finished, something like cash, which is liquid and it's going to be used, and at some point it's going to be finished, then you're better off setting up a revocable trust, so it actually takes care of that. So once that happens, of course, now the trust ceases to exist. Then we have other assets that would ideally not really be finished, something like a property or a piece of land. So that one will last for generations to generation, and you're able to pass on those assets to other people. And that's where now an irrevocable trust comes in. And you'll normally find an irrevocable trust means it will be there forever. That means that asset will be there forever, and it's meant to serve beneficiaries for generations to come, because ideally it doesn't get finished. It can be removed from the trust for one reason or another. Maybe it could be through a sale. Sometimes someone will set up a trust and say, this asset is to be maybe disposed to cover a certain facility that maybe the trust has. So that could happen. But the good thing is, even though the asset has been removed, the trust remains there, and you're able to actually place more assets in future. So it's able to take care of generations even after you have passed on, or whoever the other beneficiaries are. Thank you.
Thank you very much, Susan. In the interest of time, we had scheduled 1 hour, and I can see that our attendees, some of them are leaving to join the other daily business. So I'll request Winnie to answer that quite briefly so that we close.
So trusts and companies are not the same entity. They're not the same legal person. They might look like they're the same legal person. Currently, they are registered under the same regulator, being the company's registrar or the business registration services. But a trust is a non-trading entity, whereas a company is a trading entity. The reason why you would create a trust in a company or have a trust own a company and the company own the assets within itself is because you would like to use those assets for trading purposes. Because remember, the restriction is that a trust is not trading, but it can own the company that then trades with the assets. Legacy properties, heritage is best placed under the trust, because when you incorporate the trust, it becomes a legal person. It can sue or be sued. It has its own personality and can own the assets directly in its name. This avoids the conflict of having assets owned in the name of trustees. And, with the changeover of trustees, you constantly have to change the ownership of the assets. And similarly, it offers a level of protection to the properties that are not used for trade activity. It does not mean that it cannot now lease out property maybe for residential use, but the trust retains the legacy properties. And then if it wants to promote commercial activities, then the private company comes in to support it. So look at it as tools for structuring how a trust works. How a trust works is for the best benefit of its beneficiaries and as tax efficient as possible. If a trust cannot be charged corporate income tax, therefore it cannot run a business, because then the income cannot be received under that trust. The business income must be taxed for trade and as per the income tax regulations, therefore involve a company. A trust can be is a legal person for any kind of business entity use. So the reason why the trust falls in as a fantastic shareholder is because you don't need the company to then stop its trading activities where the shareholders or the directors are not there anymore. If the trust holds the shareholding, it protects the company, allows it to transition seamlessly without having to go through the probate or succession route. And the trust can then now appoint new directors and continue facilitating its trading activities and protecting its assets within that company as well.
Okay, thank you, Winnie. I see follow-up questions. I know that we open up the Q&A, we can have it till the kettle come back home. So allow me at this juncture just to appreciate each and every one of you for taking your time to attend the webinar. We are going to continue to answer the questions. We have the we will continue to answer to the individuals who've typed in the questions, even post this webinar, so we can do follow-ups and deal with the questions conclusively, especially the ones that I can see follow-up questions on, like on the IDD. So we'll be able to take that offline. So ladies and gentlemen, we want to extend our heartfelt thank you to all of you. Your participation and engagement really has been invaluable. We hope that you found the information shared both insightful and beneficial. So throughout the session, we tried to explore various aspects of estate planning, including, importance of, having those plans, the role of trust, strategies for minimizing even estate taxes where applicable, and ensuring that your wishes are respected. So our expert has provided knowledge and practical tips on how to navigate some of the complexities of estate planning. A few takeaways from where I sit would be that it is important for us to start early. Of course, within the country, we recently, I think 3 or so months ago, had an interview from Manu Chandaria, who indicated that he actually set up a trust earlier on in his life, before he was even the age of 21, around the age of 21 and so on. So it is important to start early because that ensures that your wishes are documented and can involve and then can evolve with your circumstances. It's also important that, these are reviewed periodically, and critically that is always consulting professionals over the course of your estate plan, so that you ensure that you have a comprehensive and a legally sound plan. Remember always, your plan is as good as not there if it has not been done within the confines of the regulatory framework that we have. So it's important for all of us to understand the tools that we have available. Finally, ladies and gentlemen, this is a continuous process, and the first step should provide peace of mind knowing that your affairs are in order. So I also want to thank the speakers, the organizers, and hope that this webinar has empowered you with the knowledge to make informed future decisions going into the future. So keep an eye out for a follow-up email. A lot of you are asking about the presentations. We're going to share that, containing the recording of today's session, along with additional resources and contact information for our team. So we look forward to seeing you at future events. Have a wonderful day and take care. Asanteni sana.